24A2. First, the Republican committees have an interest related to SB 1, which is the subject of this action. The Republican committees have clear and obvious interests in the rules under which they and their voters, candidates, volunteers, and poll watchers exercise their constitutional rights to vote and to participate in Texas elections. Those interests include the Republican committee's interest in winning elections, their expenditure of resources on get out the vote and other volunteer efforts, Republican voters exercising their right to vote, and SB 1's regulation of poll watchers appointed by county parties.
Counsel, as I read the exchanges with the district judge below at the hearings and so forth, what he said to you, first he tried to get people to file a common complaint, and that didn't work out. But he simply said, when he denied the motion to intervene, that you're represented by the Attorney General, well represented, as his interests are, and you can file amici briefs. Why isn't leave of filing amicus briefs give you participatory rights that are adequate? That was the district court's, I think it is correct, that's what he said, offered, that file amicus, come in as amici.
Permission to file amicus briefs, Your Honor, is no substitute for intervention because
well, of course it is, but what interest of yours would could you not vindicate just as well coming in that way?
Well, we have no opportunity to shape the record, to participate in trial, or to present arguments on the merits beyond what the parties may present themselves as amicus.
What would that be on the facial challenge, which is what this is?
So, as I mentioned, we have an interest in Republican...
Is this a facial challenge?
There are, I believe, as-applied challenges and perhaps facial challenges in this case by the plaintiffs, you mean? Maybe I don't follow the question.
Well, I thought your argument has a lot of purchase with regard to both counsel to the question of watchers, and some threshold suggestion that wasn't adequately presented to the court. It'd help me if you would address that.
Certainly, yeah. We believe it was adequately presented to the court for a couple of reasons. First of all, as we mentioned in our briefing, we have an interest on behalf of our voters, members, volunteers, and election observers. Election observers is another term for poll watchers. And that interest is one of the many interests that's implicated by SB 1. Our committee, the committees themselves, but also their voters, candidates, and volunteers are affected by SB 1. There's no question about that, since SB 1 regulates elections in which the committees themselves and their voters, volunteers, and poll watchers participate. So that was an interest that was raised to the district court through the prism of volunteers, members, and election observers. And the district court did not hear argument on this particular point. We would have been pleased to
Does your petition and intervention, it says observers, or does it say, which does it say?
It says members.
Members?
Yes, members of the parties themselves. And of course, the poll watchers are members of the party since they're appointed by the county political parties. And then we more specifically mentioned election observers in the reply brief as well. Even in addition to that, though, Your Honors, there are other interests that the Republican committees put before the district court that are sufficient to warrant intervention here. Take, for example, the interest in winning elections. That is an interest that has been recognized by other courts as sufficient to warrant intervention.
We can't give you a lot of help on that. We shouldn't in any event, on either side.
Point well taken, Your Honor. But it is an interest, like the interest in poll watchers appointed by county parties, that may be implicated by the resolution of this litigation. The plaintiffs seek injunctions against SB 1, either in total or certain provisions of SB 1, and any such injunction might impair the Republican committee's interest in upholding SB 1. The defendants would be bound by any final judgment and final injunction in this case, and the Republican committees would have no recourse to protect their interests absent intervention in this case. And finally, on adequacy of representation, there's no adequate representative for the Republican committee's interests among the existing parties of the case. There's no party that has the Republican committee's interest in advancing the electoral prospects of Republican candidates, protecting the right to vote of Republicans on behalf of those candidates, or protecting the rights of poll watchers that are regulated by SB 1 and appointed by county political parties. Moreover, even the state defendants don't share those particular interests because they represent broader interests than the Republican committees, and they, of course, don't have the more parochial interest in upholding Republican electoral fortunes or advancing the cause of Republican candidates. Moreover, the state defendants have staked out a position at odds with the Republican committee's position. They've sought dismissal on immunity grounds. And this is a unique case. If the state defendants are dismissed on immunity grounds, the case itself would not be dismissed in its entirety because other defendants also have been named in the case. Now, there's no argument that those local defendants adequately represent the Republican committees. So what you would have, if the state defendants were to prevail on that immunity defense either now or at some point in the future, is a lawsuit against defendants that do not, under any argument or construction of Rule 24A2, represent the Republican committee's unique interests in this particular litigation.
Where are we procedurally? When is this all set? Do we have a schedule when there's going to be a hearing, resolution?
Yes, so far there is a schedule in place where discovery is proceeding in the district court, which is why we asked the court to expedite our appeal, and the court, we thankfully granted that on our behalf. Discovery continues into May, and trial is scheduled for July.
But how do your interests differ from as a party, from the Attorney General's interest?
The Attorney General has a variety of interests that are broader than the Republican committee's interests,
Right.
and doesn't share all the Republican
Well, I
committee's
understand
broader
that
interests.
he has a great deal of power, and he also is a Republican-serving Attorney General.
He is, although as a sworn state official.
And he's not a stranger to litigation, of course.
Of course not, and the Attorney General's office is no stranger to this type of litigation. At the same time, as a government actor, the Attorney General's interests are much broader than the Republican committee's interests.
Well, one thing that comes to mind is he could lose the November election and Democrat be elected the AG before we get an appeal of, assuming there's a July trial, before we get an appeal of that. So.
That certainly could happen, Your Honor. And that would be similar to the dismissal of the Attorney General that could be possible on immunity grounds, which the state defendants have already moved for. And in that scenario, there'd be no party left to defend this particular statute statewide. Now, we propose to represent thousands and thousands, if not millions, of Texas voters who have an interest in this particular litigation and in this particular statute. Similar to what the plaintiffs.
How would it work if the AG got dismissed? Who would be left in this case? Would be the counties?
There are a few county officials that have been named as defendants in the case, yes, Your Honor.
And they're not similarly situated to your client, are they?
They are not, and there's been no suggestion in the case that they're adequate representatives here, nor could they be. In fact, one of the local defendants, Isabel Longoria, who from Harris County, is challenging SB 1 in a separate lawsuit. There are other county officials who have declined to defend SB 1, and none of the current county officials have moved to dismiss the case. So none of those officials are adequately defending our interests on a statewide level on behalf of all Texas voters who favor Republican candidates and who want to see Republicans win elections. So similar to the plaintiffs, we're raising the same interests that many of the plaintiffs have raised to support their Article 3 claims of standing in this case. They claim that they have an interest in get-out-the-vote efforts and in spending millions of dollars on get-out-the-vote and volunteer efforts. We've identified exactly the same interests. They claim an interest in winning elections and in seeing their candidates be elected. We've identified exactly the same interests.
Why isn't this very similar, perhaps this is a friendly question, to the DAPA case, where the government purported to similarly represent the interest of the persons, you know, the DAPA, the people who were recipients of DAPA, but they weren't because they wanted to give them a status, an actual legal status, rather than just allow them to not have to leave. And so they had a stronger interest in pressing the point. Even if they're pressing the same point, they press it from a different way and with a more fervent, different result, you know, if they win the same point.
That's absolutely right, Your Honor. And we think the DAPA precedent is directly on point. That's Texas versus United States, which is why we've cited it heavily in our briefs, as well as Brumfield. Brumfield's another case from this court which dramatically underscores that private individuals may have different interests that are not adequately represented by
Because
state or
it's
local
what's
government actors.
emphasized. It can be not just up or down, but what is emphasized and how does it go about in improving the case?
That's absolutely right, Your Honor. In addition, in Brumfield, the court suggested that it's sufficient just to show that the government actor has broader or different interests than the private party. Particularly, and moreover, even if that were not sufficient, the Brumfield court reasoned that it's certainly sufficient if there's been a different or contrary or additional argument been advanced by the party or the putative intervener. And we have that here because the state defendants have raised their immunity defense, which is not a defense that we can raise, nor is it a result that we want to see happen, because we want SB 1 to be upheld on a statewide basis. So if there are no further questions, I will reserve the remainder of my time for rebuttal.
Good morning, and may it please the court. Uzoma and Nkwonta, representing the LULAC plaintiff groups. I will be arguing on behalf of all appellees that signed on to our brief, and I will be addressing the second and third elements of the Rule 24A2 analysis, and Counsel for the United States will be addressing the fourth element, the adequacy of representation. The district court correctly denied the party committee's motion for intervention of right because they asserted a raft of generalized interests, but they offer no clear explanation of how those interests were implicated in this lawsuit. And they did not explain how the disposition of this lawsuit would actually impact their interest. And as a result, it's still unclear, even in their briefing on appeal and in their briefing below, what they stand to lose or gain from this lawsuit.
How do you distinguish the interest, their interest from LULAC? They have different outcomes, but LULAC is obviously a familiar litigating party, represents a long history. You're familiar with that? And on the one hand, LULAC is here and we're protecting those interests. How would you distinguish that from Republicans?
Well, Your Honor, LULAC's interest and the interest LULAC claimed—
On this point.
Certainly. LULAC asserted this claim on behalf of itself and on behalf of its members, and LULAC alleged that its members are going to be unduly or unconstitutionally burdened and are going to be denied an opportunity to vote because of the provisions in SB 1. Now, contrast that to the interest that the party committees have asserted. The party committees have asserted interest in the subject matter, but they have never actually connected the interest in the subject matter, SB 1, to—
Well, what if the Democratic Party came in and said, we agree with LULAC, this is going to affect members of the Democratic Party and their right to vote? Is it proper to let the Democratic Party intervene?
Well, the Democratic Party would be subject to the same standards. And if the Democratic Party can demonstrate a personalized interest, not just a general interest in subject matter, then they would also have to demonstrate—
Well, they're going to say Democratic voters are going to be impacted, so we're just like LULAC. We should be admitted.
Then the court would have to analyze the remaining factors, but that can be a personalized interest. And if the Republican committees had argued that these laws prevented their voters from casting a ballot, or that these laws somehow impeded their voters' ability to participate—
What if they say our interest is protecting the validity of the votes, preventing fraud, that sort of thing?
If that was the interest advanced by the Democratic Party or any other party, well, they should be subject to the same requirements, which is that they need to demonstrate why those interests aren't adequately protected by state parties whose role it is to also prevent fraud and also ensure integrity.
So we're going to have the voter rights cases and so forth. We're going to have the automatic admission of the Democratic Party and the Republican Party. So the state attorney general is going to be out of work.
Well, Your Honor, there are a number of different factors that go into determining whether a political committee can be an adequate intervener. And those interests It's important to ensure that those interests are connected to the litigation, because otherwise you would have a...
Well, let's take the poll watchers, or what the current name is. As I read the statute, they have, the state has adopted rules with regard to poll watchers, including some kind of a certification process and some schooling to prevent harassment and so forth, which is an improvement over over time, for sure. What do we say about that provision? Why doesn't the party have a direct interest in that?
Two responses to that, Your Honor. First, the argument rests on the faulty premise that merely being regulated by certain law creates a personalized interest. And that is a boundless interpretation of the intervention of right, because when you look at election laws and you look at the rules that apply to voting laws, they impact a number of different actors in the electoral process. So the laws in SB 1, for instance, they govern the conduct of voters, election officials, poll watchers, and numerous other stakeholders. And the notion that being regulated is enough, that would essentially lead to a expansive right to intervene that is effectively boundless. But secondly, it's clear from the briefing below that this argument was not raised and is not properly before this court. There are references to poll observers, to be sure, in the party committee's reply brief below, but there's no argument about the regulation of conduct of poll watchers. That's a different argument, and it's not enough, as this court has specified in its prior precedent. It's not enough to merely intimate the argument. If a litigant desires to preserve an argument for appeal, the litigant must press that argument. And it's telling, when you look at the briefing below, that none of the parties, not the party committees, not the parties opposing the motion to intervene, and not the court, not a single party discussed the regulations of poll watchers or argued about that. This is essentially the first time that these parties are arguing about the conduct or the regulation of conduct to poll watchers. And that's a demonstration. The fact that it never came up in any party's briefing below, that's an illustration, and further demonstrates that they did not preserve that argument.
But they did talk about the resources they spend in the recruiting and the training and the appointment, and that all of that training is going to be different now. So the expenditures may be greater because they're going to have to, it's not like you've done this for 25 years and you do exactly the same thing. You have to know the new rules and you have to be up on them and ready to go and report things. So why isn't that good enough, bringing it up by saying that they have to advance the expenditures for the poll watchers and the training for the poll watchers, and the training is going to be different because of this?
I see that as a separate argument, Your Honor. I agree they did bring up the expenditure of resources. The specific poll watcher conduct argument is slightly different because they are attempting to suggest that the regulation of appointed poll watchers therefore creates a protectable interest or a legally protectable interest. Now, the expenditure of resources, that's a separate potentially protectable interest that they argue in their brief. But as this court has recognized, especially in NOPSI, New Orleans Public Service Incorporated, the economic injury, the expenditure of resources alone is not sufficient to demonstrate a right to intervene. The party committees do not suggest that they are diverting resources from some other critical activity or some other critical endeavor. What they are doing is they're spending resources to get out the vote and to train their poll watchers, which is what they typically do and what they would be doing in any event.
And to recruit the poll watchers, and they're different now, though. The poll watchers themselves may be different people because they may not be qualified, the prior ones, because of the new qualifications, particularly for party poll watchers.
That's potentially an argument, but that's an inference and a step that has not been spelled out or has not been identified in their brief. They're not suggesting that they have to recruit new poll watchers, and they don't identify any specific provision that actually changes who would be entitled to be a poll watcher. In fact, all they have alleged, even in their appellate brief, even assuming they raised this issue below, all they have alleged is that the regulations of they're interested in the regulation of poll watchers. but they haven't ever explained whether that regulation of poll watchers actually impairs a specific interest and whether they have anything to lose or gain from the regulation of poll watchers. It's another example of an interest in a subject matter, an ideological interest in a subject matter without the requisite connection to the underlying litigation. And if you look at this court's precedents, a common thread and a common theme in those precedents, including the ones that the court discussed with opposing counsel, is that the parties who are permitted to intervention of right, they don't just have an interest in the subject matter. They practically have something to gain or to lose by the resolution of the underlying litigation. In the Texas versus United States case, the undocumented individuals, they were at risk of losing an opportunity to gain access to a program that could have ensured them unlawful status. In Edwards and in black firefighters, the potential interveners were at risk of losing an equal opportunity to promotions to which they may have been entitled. In Brumfield, the parents who sought to intervene in that case were at risk of losing vouchers that would allow them access to the full range of school choices. For whatever reason, the party committees failed to define their interests or explain how those interests are implicated in this litigation. They cannot explain what they have to lose or gain from this lawsuit, and that's why the district court's decision should be upheld. Thank you.
Good morning, Your Honors, and may it please the Court, Katherine Lamm for the United States. I'll be focusing my time today on the final factor necessary for intervention of right, which is inadequacy of representation by existing parties. Beyond failing to demonstrate a concrete, personalized, and legally protectable interest in this litigation, the committees also have failed to meet their burden of demonstrating a serious possibility that the state defendants may not adequately represent their claimed interest in defending SB 1.
Why does the United States care whether the Republican Party comes into this case?
Well, the United States is a plaintiff in this case and has an interest in moving forward expeditiously and efficiently without the case being gummed up by an additional party, which, as Chief Justice Roberts noted in his concurrence in South Carolina versus North Carolina, will bring in additional discovery requests, additional objections, additional issues, which, as a party that offers no new issues or questions in the case, can instead do as amicus, more efficiently and more expeditiously. So this is a case that is on an accelerated timeline. Discovery is well through its course. Expert reports are being exchanged. The close of discovery comes on May 13th. Dispositive motions are due on May 27th. Trial.
The court could make this all say, you can come in, but you've got to start running. And you got to we're keeping our schedule. There's nothing that would prevent the court from doing that.
Understood, Your Honor, but what this court thought what the district court felt was more appropriate in this case was to offer the opportunity to participate as amicus, which is what this court in numerous cases, such as Hopwood, Bush versus Paterna, I believe, the court has said is an adequate way for a party that does not demonstrate a concrete interest in the litigation and whose interests will be adequately represented by a party with the same objectives can do.
All interests were not adequately represented by the United States in the DAPA case.
Your Honor, I think the DAPA case actually is a great example of where a party's interests were sufficiently divergent. The court, in your opinion, Your Honor, in the DAPA case, you noted that the divergence of interest needed to be germane to the litigation. And you looked for an actual demonstrated difference of both objective and position in the litigation. And what was different in that DAPA litigation that you focused on in determining that the putative intervener's interest was sufficient was that the federal government had sought to make an argument claiming that the states would be able to deny driver's licenses to the women. And that was one of the very interests that the court emphasized as being sufficient to satisfy those first second and third factors in the intervention of right analysis.
What about the additional expenditures of the poll watchers and the new trading, and whether or not they're going to be penalized in some way under the new regulations?
Well, first, Your Honor, we take the same position as the private plaintiffs that argument regarding regulation of the poll watchers' conduct was not raised below and thus is forfeited.
Expenses of the poll watchers.
The expenses is the same argument they seem to raise with respect to all of the committee's other activities. So getting out the vote, training voters, whatever materials they need to provide, that argument may not really even be any different. Nevertheless, focusing here on adequacy, the committees have identified no reason why the state, including the Secretary of State, who is the one who promulgates the training that is created in SB 1, would not share their interest in upholding the law and ensuring an expeditious result that clarifies what the actual guidelines for the election will be.
How does it affect the case about if the Attorney General's not in the case?
Well, Your Honor, that's certainly not the case at the moment, and that is a highly speculative future, possibility if the...
Don't they often move to get, the government officials getting out of these cases is a very common move, so it's not that highly speculative, is it? I'm not saying they're entitled to it by any means or foreshadowing that, but it's a very frequent litigation tactic in this area.
Understood, Your Honor. Our position would be that it's highly unlikely that they will succeed on those improbable arguments. Nevertheless, what this court has held in cases like Sierra versus Espy is that premature intervention is not appropriate where it will waste judicial resources. And here, the committees have entirely based their position on hypothetical and speculative divergences of interest that they do not in any way connect to this litigation, which is about whether or not SB 1 violates federal voting and civil rights laws, and whether it violates the Constitution. It's not clear which interests of theirs will be raised in this case other than simply knowing what the law is. And we have no reason to believe that the states won't be representing them. Nevertheless, should the court even have to consider this at some point, it's hard to say that the dismissal of the state entities from the case necessarily even would be to the detriment of the committees, as the elimination of statewide relief could in fact be, arguably beneficial to them. So at this point...
And they could have, perhaps the plaintiffs could have sweetheart deals with certain counties that are favorable to their moves. And then that puts no one in a position to object to those sweetheart deals. And I don't mean anything that's not pejorative, but where they all have mutual agreeable interests, and so it's a judgment that is very agreeable rather than a true adversarial nature.
Absolutely understood, Judge Elrod, but I think this is where I would urge the court to look back at its decisions in Sierra Club and Bush versus Viterna about how the mere possibility of future divergences of interest simply is not what the court looks to when it's trying to decide intervention of right. What it looks to is actual demonstrated divergences of interest that are in the record. So like the ones that Your Honor found in the DAPA case, like in Brumfield versus Dodd, like in Veazey versus, as was not found in Veazey versus Perry and Hopwood. Those are cases where simply broad conjectures about broader state interests, concerns that certain arguments wouldn't be raised, that's what the parties relied on in those cases, and where this court in cases like Brumfield and the DAPA case said, no, that's not enough. You need to have what the parties in this case have, which is actual differences in objective and in argument. And they have to be demonstrated through the record in the case. That is what this court has looked for, not the mere possibility that down the road some divergence of interest might occur.
Let me ask you a question. How do we apply the basic teaching that ideological differences is not sufficient to intervene?
Well, I think that principle is very important in this case. The committees haven't, I understand certainly they think this is a good law. SB1, they like it, they'd like to proceed under it, but that alone is not enough. They need to demonstrate some way in which they will gain or lose in the case, and they need to demonstrate something in the case that the state defendants won't as well seek to represent. And every sign in this case is that the state defendants are vigorously and comprehensively
in one sense, whether it's a Democrat Party or the Republican Party seeking intervention, how do you apply the principle that their ideological differences are not sufficient?
Well, I think Your Honor's question goes to the notion that administrations could change. Certainly in this case, the state defendants...
It doesn't matter. What I'm saying to you is that ideological differences, that the political party has got to demonstrate something more than ideological differences. We want to be present. We want to be on the scene. We want our voters to know that we're standing up for their cause, either side, et cetera, as distinct from interests of LULACs are on one side and Republican interests on the other side are quite different. And parties that seem to me are quite differently situated. But what I'm focusing on is this very strong reluctance to allow people to come into lawsuits because of their ideological differences. Because they could file a MAKI, they can support their cause, but whatever, giving money to hire the very best lawyers, whatever they can, without being present in the courtroom. In fact, it may be better to get better lawyers.
Certainly, Your Honor, we think that in this case, to the extent that there is an ideological interest that the committees wish to share with the court, they have the opportunity, have been given the opportunity to present that as a meeting.
Oh, and they take advantage of it, too.
I am certain that they will do that if they deem it advantageous to their needs. I see that I'm out of time, so unless the court has any further questions, if I may, I just wanted to conclude that the committee's failure to show that they have concrete, personalized, and legally protectable interests in the litigation, or that the state defendants may inadequately represent the interests that they have, dooms their effort to intervene by right, and thus the court should affirm the district court's decision to deny their intervention motion. Thank you, Your Honors.
For the reasons we've laid out in our brief, the court should reverse and grant intervention of right. None of the arguments we've heard today change that outcome. The first set of arguments is that the Republican committees have asserted only generalized interests or ideological interests in this litigation. That's simply not correct. The Republican committees have asserted the same interests that many of the private plaintiffs have asserted, which are the interests in expending their resources on get-out-the-vote efforts, on training volunteers, and also the interest in winning elections. We do agree with something that Plaintiffs' Counsel said just a few moments ago. He said that in other cases, such as Texas or Brumfield or Edwards, the putative intervener had something to gain or lose in the form of a, quote, opportunity. In Edwards, it was the opportunity for promotions. In Texas, it was the opportunity to remain in the country. In Brumfield, it was the opportunity to participate in a scholarship program. What we are looking for here is to protect our right to an opportunity to win elections and to participate in elections under the rules that the legislature has adopted. It's the same interest that has been upheld by this court as sufficient to support intervention time and time again.
But that reasoning, could you intervene, the party intervene in virtually any voting rights suit?
We believe that we have an interest in voting rights generally and in voting rights suits. That's certainly correct.
So,
whether intervention...
we have a lot of voting rights cases, litigation going on, and some private litigants and so forth. So the party as a matter of right, can come in every one of those. I'm not suggesting you would, but...
It would also depend on the individual case, Your Honor, because, of course, in every case we have to satisfy Rule 24A2.
Well, every voting rights case involves the application of the voting rights laws, and et cetera, and that's your interest.
We have that interest, and if that interest were impaired and not otherwise adequately represented, and we could satisfy Rule 24A2, then the rule requires that intervention be granted. Merely because the interest is widespread and held by many people doesn't make it a generalized interest insufficient to support intervention. Voting is near universal. It's universal for every eligible individual. The plaintiffs purport to represent thousands or perhaps even millions of Texas voters in this particular litigation, all of whom they claim are harmed by SB 1. We're representing thousands or millions of voters who claim to be benefited by SB 1 and want to see it remain in place. It's the same interest on either side of the litigation. Therefore, if it's a sufficient interest for Article 3 purposes for the plaintiffs, it's certainly sufficient under the more minimal standard of Rule 24A2.
So the party could meet the standing requirements of Article 3?
The party here does not need to meet the standing requirements of
I
Article
know
3,
that.
but
That's
I
not my
appreciate.
question.
I understand your question, Your Honor, and I think political parties bring this kind of litigation all the time, and have done so in Texas and in other states. And finally, on adequacy of representation, we've shown what was shown in Brumfield and in Texas.
You can meet the redressability standards of Article 3 as a party?
Certainly on behalf of voters in the party, that has been upheld as sufficient for Article 3 purposes, Your Honor.
All right.
In any event, on the adequacy of representation point, no other party in the litigation represents the interests of the Republican committees, and we have, as in Texas and Brumfield, a difference in contrary arguments being presented by the state. So for all these reasons—
You make all these arguments in the district court that so clearly that you made in the briefs here. I mean, you know, it remains to be seen whether you've made them or not. We haven't decided that. But you made them a lot clearer here.
And we believe we made them clearly in the district court as well, on behalf of members and election observers. We also, this district court was one of the first district courts to deny intervention to a political party in one of these cases. It's been routinely granted by courts all across the country, as we cited in our brief to the district court. For all of these reasons, we satisfy Rule 24A2. The district court erred in denying our motion to intervene, and we ask this court to reverse.
Thank you, Ken. That will conclude the argument.